my name is Attorney Walter Rudolph Hnot III, and I'm with Disability Resolution PA, a disability law firm in Orlando, Florida. I know a lot of you guys have seen the videos that I've done throughout the years, but what I wanted to do is focus on a topic that really no disability attorney spends time on because it's just not a popular topic, and that's what happens when you get a denial, okay? So there's many areas where you can get a denial, and it's basically where you fail one of the elements of the 5-step sequential process. So let's go ahead and talk about what I mean by that. So there's these 5 elements, for a standard disability claim, not a child claim, that's 3 elements, or a CDR, that's 8 elements, but for a standard disability adult claim, there's 5 elements. And if you fail one of those elements, you can always look up a video on, 5-step sequential process. If you fail one of those elements, it means that you didn't meet the requirements of one of those elements. So let's say you get a denial at initial filing, right? Well, initial filing has a pretty high up percentage rate for being found disabled. And one of the things about that that's interesting is that a lot of people who get a denial at the initial filing level also get a denial at the reconsideration level. Now, some states don't have reconsideration as an actual level. They just skip it. They get a denial at the initial filing, they go straight to the hearing level. I like this for some reasons, I don't like this for other reasons, but I want to talk about denials right now. So let's say you get an initial filing denial, you're very likely to get a reconsideration denial. Most of the claims that are flopped around that basically go from an initial filing denial into a reconsideration approval, those types of claims usually had a technical denial issue at the initial filing level. They didn't show up for their CE, something happened, and it was a technical denial, it wasn't a medical denial. Now, most of you are concerned about your ALJ denial, Administrative Law Judge denial, okay? What is an ALJ denial? Well, what you get in the mail is a brief. Could be anywhere from 3 pages long to 40 pages long. Could be anywhere in there. And what that brief tells you, at the very top of it, well, in the middle top of it, is one of 3 flavors. There's unfavorable, partially favorable, and fully favorable. Okay, so what are these 3 flavors? Now, there's 5 main ways, things that could occur at that level, but there's 3 main flavors. Unfavorable. You're denied disability benefits because you didn't meet one of the elements or the requirements of one of those elements of the 5-step sequential process. Okay, so what do I mean by this? Why is this relevant? Why is this something that we are concerned with? Because a lot of people actually get a denial. And when they get the denial, they go through a lot of stages of regret. They go through a lot of stages of anger, hatred. They hate the judge. They hate their attorney. They hate the court reporter. They hate the vocational expert. They're looking for where they're going to place the hate. And that's natural. That's how humans do it. I mean, that's just kind of the basic thing. So with that said, okay, if we get a denial, what is the first thing that we should do? Right? What's the first thing that we should say, okay, I got a denial, what should I be thinking? First off, you have 2 options. Really 3, but if you're not represented, you only have 2 options. Option number 1 is that you're going to go ahead and appeal to appeals counsel, right? That's the next step up. You're going to appeal it into the AAJ, Appellate Administrative Law Judge, level. Okay. Option 2, you can go ahead and refile for Social Security disability benefits. Okay. Those are your 2 main options as to what you can do at that point. Now, if you have an attorney and the attorney notices something that's relevant to what was done improperly by the judge that can be easily fixed, like something wasn't properly submitted or something happened, they can always notify the judge and request basically that they withdraw the denial to go ahead and fix something for a new decision. It's extremely rare, but it does happen. So you've got, and then of course the other option too that a lot of claimants don't utilize because it's not a wise one that I don't even bring up, but I'll bring it up just for the video purpose. They go ahead and just sit with it. They don't do anything thereafter, they just sit with their denial. Okay. So, what is smart about refiling the claim? Well, you've waited a while to go to the administrative law judge hearing, right? You've collected a lot of medical evidence during that time period. Or maybe you're one of those claimants that just never went to the doctor. Maybe you're an I-2-1-40 subsection A 5, you just couldn't get to medical because you're homeless, don't have transportation, whatever. Okay. So with that said, it might be an issue where you don't have a lot of medical evidence built up, and you're going to need medical evidence either way to go forward with this, because that's part of the structural necessities of being found disabled. So one good thing about refiling is you've got a lot of medical evidence usually built up, because most people keep going, for medical treatment throughout the process. Another thing is that at that point, you've had enough time to go ahead and learn how the process works a little bit better. So when you go and answer those forms again, in the 3373 form, the 3368 form, the 3369 form, you can put down answers that you feel will better negotiate the disability process. Okay. Another thing about refiling is that if you screwed up during the initial filing reconsideration, or ALJ, like you called the SSA and you told them you were fine, or you got caught with a bunch of drugs, tobacco, alcohol, whatever on your record, this is your reset button. Okay? So there's all these things you can do with refiling, and reasons that refiling would be a good idea. Now, I tend to look into and prefer filing for appeals counsel. Appeals counsel is where the attorney, very rarely the claimant, but the attorney will go ahead and argue that the ALJ made some sort of error as to law or fact, right? The ALJ didn't consider, enough or give enough weight to the, to the claimant's physicians that are seeing physicians. The ALJ misstated some sort of law. The ALJ put in his brief or her brief that, basically, claimant stated this, and then you go and look at the form and you realize that's not what the claimant stated. A classic one that I see is, well, the claimant is capable of horseback riding and, taking care of goats and, animals and yada, yada, yada on a farm. Ergo, why wouldn't they be able to do a job related to that, or a job with transferable skills with that? So in that regard, you'd want to check, because that's material. They made an error as to the facts. They screwed up as to which facts were to be stated, or were misstated, or incorrectly written into the brief, whatever. They made an error as to the facts. So this is important, and it's important because at the end of the day, what you end up with is the potential for all that back pay growing to be even more back pay, right? Because the first thing on your mind, I know you're thinking, is, I'm going to lose all that back pay. Not necessarily if you go to appeals counsel, okay? All right. Now, let's say you get a denial at appeals counsel. What should you be thinking at that point? Now, remember, appeals counsel's got a very, very high percent very high percent denial rate, which means that most people who go to appeals counsel get denied, and most people that go to appeals counsel takes anywhere from 9 months to 2 years. Most of them take around 12 months to 15 months. So when you're sitting there going, and I know how you guys are, he said 9 months, therefore I should have a decision in 9 months. Don't be that idiot. Just don't be that idiot. And I know a lot of you guys have tendencies where you just want to turn into that guy, and I get it, but remember, 12 to 15 months is the usual. Sometimes it takes 2 years. Okay. So you're in appeals counsel. You can get a couple of options. You can go ahead and get a denial. You can get a remand, which is kind of like we're going to send it back to the judge. We're not approving it, so it's like a quasi-approval, quasi-denial. You can get an approval. Or they can have some weird administrative thing applied to it. It could be a technical denial, could be a dismissal, could be some weird thing where a higher up goes ahead and grabs the claim and reviews it, some other group. Because they're doing a lot of that now to basically try and see if they can speed up the ALJ process, to see if there's a chunk of disability claims that meet certain word requirements within the system. They go ahead and grab those, kind of like with search terms, and say, okay, these are more likely to be found disabled, these are not, so that these are more likely to be found disabled. Go to a special group, they review them quickly, and then poof, they spit them out, and if they're good to go, they'll approve them right there. That way they don't have to do the whole hearing gig, or even the appeals counsel gig. So let's say, because remember this whole video, and keep in mind I'm driving, so I'm focusing on this, but let's say that you get a denial at appeals counsel, right? Then what should you be thinking? Well, then you've got a couple of options. You can either refile, or, you know, refile for disability benefits. Same gig, same kind of yada yada. This is a good chance where you get to have a lot of medical evidence right up front, add a little bit more medical evidence to it, to see what you can do to try and get through. You can correct mistakes that you made on the forms when initially filing. You can go ahead and basically, you know, make sure things are more prepared in a timely manner, that you get more statutes helping you out. You can do all those things. Now remember, something special happens after an appeals counsel denial. At that point, you can go to federal district court. Once again, federal district court. Okay, so at federal district court, you know, I'm Central Florida, so Middle District to Central Florida is what I practice in. At federal district court, once you get out of the SSA docket just means, like, you know, the SSA, Social Security Administration's disability docket. It means it's a little trial system, a little hearing system. Once you get out of that and go into the district court, the federal district court stuff, you can refile and still keep that old claim going. So you can have two claims against the SSA at once. So at that point, though, you gotta have an attorney. I mean, you would be absolutely, I don't even know how you would begin the process without having a knowledge and background in studying appellate law. But you need an attorney no matter what at that point to be able to go ahead and file in district court. That's just the bottom line. Okay. Now, so you've got that option. You can continue the claim by filing into district court and at the same time file an initial filing. That's what a lot of the smart people do. They try and find an attorney that will go ahead and take it into district court. And then they start a new claim at the same time. Now, what usually happens is if we have to take a claim through appeals counsel and district court, what will usually happen at my firm is, okay, so we get a denial at ALJ and AAJ at appeals counsel. We take it to district court. We'll file a new claim. We'll usually win that new claim before a decision is made at district, you know, at the federal district court level, and then we'll use that as evidence to show how they should have been found disabled under the SSA docket, and then usually they'll deliver to us a district level, federal district court level decision. Now, if you guys aren't really sure how that all works, like what's the hierarchy, yada yada, so it's initial filing, reconsideration, ALJ hearing, appeals counsel with the AAJs, then we go to federal district court. Right, so now we're leaving the SSA docket, federal docket. So now we're going into district court, circuit court, and the Supreme Court, as in like the Supreme Court of the United States, the Biggie Fry, the mega court, the home of the whopper of law. That is the big court, right? The people you see on TV, you know, Ginsburg, yada, 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 so on and so forth. Those are the ones right there that literally it goes to. So you're on a highway to going to the highest court in the land, if you can be certified to actually go there. Because, you know, they have to certiorari and do all that jazz to allow you to even go before that court. Okay. So let's talk about that real quick. You get a denial at appeals counsel. Pretty much at that point, you're going to refile no matter what, because if you go to district court, the next level, you can still have a new filing. Where you can't do that in appeals counsel. If you basically go into appeals counsel, you can't file a new claim at the same time while being adjudicated at appeals counsel. You can do that once you're out of the SSA docket into federal district court. So these are the things that you need to be thinking about when you get denials. A lot of you guys are like, I'm not sure where to go with this. I'm not sure what to do with this. That's kind of your hierarchy. Now, I meant for this video to be more of an emotional, like what you should be thinking video, but it didn't turn out to be that. So I'll do another one as I'm driving up on 95 to go ahead and explain basically the emotional stance of what you should be feeling and how you should be healing yourself from that denial. All right? My name is Attorney Walter Rudolph Hnot III. I'm with Disability Resolution PA in Orlando, Orange County-based Social Security disability law firm. If you have a question, you want the most up-to-date information, you want a custom video made, that's fine. Shoot me an email or give me a call. We're going to be doing a lot of structural stuff with all these videos to kind of help you in the future, be able to find them and stuff like that. We are also, in the very near future, going to be hiring people to help with the YouTube channel. So if this seems like something you might want to do, Cool. Give me a call or an email or whatever. Send me your resume, and then from there we'll go ahead and see if we can get you a job working on the YouTube channel and doing some back office functions with the advertising side. All right. My name is Attorney Walter Hnot. You have an absolutely wonderful day, and we'll go from there. Thanks so much. Bye bye.